Okay, so this week we're looking at criminal responsibility. I want you to keep in mind that the blue book, the chapters we're using, we're blending this information in. You're going to want to go back and review chapters 2 and 1. All the material from the blue book is going to be added as far as exams and everything in this course. So keep reviewing that blue book so that you get better at reading criminal laws. So this week we're looking at defenses as far as insanity, diminished capacity, and age, and how they are used to eliminate or reduce a defendant's blameworthiness as far as the crimes go. So even though the defendant committed the criminal act, so we've got the actus reus, we don't necessarily have the mens rea. And if a crime requires the mens rea and that person doesn't have it, that's where we start looking at these type of defenses. Okay, so as far as learning objectives, we're going to talk about, what is a child based on the legal standard. As far as age, from 7 to 14 is when we start looking at that person being eligible to be criminally charged. We'll talk about the McNaughton rule, cognitive versus volitional approach, and then substantial capacity test. Identify the extent to which alcohol or drugs is going to be used as far as a defense, not guilty by reason of insanity versus mentally ill, and factors that present issues of criminal defendant's competency. So, looking at the vocabulary, a trial by ordeal, very old way of solving issues. Basically, might makes right, for lack of a better word. If you won, you were considered right. Preponderance of the evidence is used a lot in juvenile proceedings, civil proceedings, basically more likely than not. And then rebuttable, which another word for that would be dispute. Presumption means presumption may be overcome by the presentation of evidence. So what they're saying here is that if it's a rebuttable presumption, the evidence can say that it's different. So infant, under civil law, a person who's not reached the age of majority, whether the age is 18, 19, 20, 21, depending on what state that you're actually in. Right now, ours is 17, but that is changing 2021 to age of 18. Insanity test to determine legal and moral inability. Insanity is a legal, not a medical concept. So right and wrong test, we'll look at that. McNaughton rule, we'll look at that. Substantial capacity test. Can a person distinguish between right and wrong, and can they conform their behavior to those right and wrong? Guilty but mentally ill. Defendant may be found guilty but mentally ill if all of the following. Defendant is guilty of the offense. Defendant was mentally ill at the time of the offense. And the defendant was not legally insane at the time the crime was committed. So diminished capacity, defense for criminal responsibility based on the fact that because of mental or emotional conditions, the defendant did not possess the required mens rea. Remember mens rea as far as purposely, knowingly, recklessly, and criminal negligence. So you'll want to go over those again in Chapter 1. Competency to stand trial. Defendants must have the ability to cooperate with their attorneys. If they can't cooperate with them, they can't assist in their own defense. Then criminal liability of corporations, the rules for making corporations liable for the actions of the people that work and or own that company. So Clark v. Arizona, insanity tests have historically followed one or more of the four approaches. Cognitive, so cognitive is thinking, moral incapacity, volitional incapacity, can I control myself, and then the product of mental illness. So again, we talked about this just a second ago. Trial by ordeal, torture imposed with hope of miraculous deliverance. Some of the trials that they would use during this period were very, very brutal. Injury, burning, branding, and then actual physical confrontations. Basically, the accused is thought guilty if he or she comes out in second place. So the winner, or again, might makes right, the winner was the one that was considered right by this action. So let's start looking at capacity and responsibility. Criminal responsibility and capacity are generally seen as potential excuses for the commission of acts. So we're saying that the act was committed, but one of these reasons is going to lessen as far as the punishment goes, if there's any punishment whatsoever. So infants, insanity, and incompetent defendants are the ones that we're going to be looking at. So preponderance of the evidence, we hear this a lot again in juvenile cases, level of proof that's generally inclines a person to believe one side of an issue than the other. So a term that I like to use is more likely than not. Does not require remove of all doubt. Most states require that defense prove insanity. And when we look at Atkins v. Virginia, that's where we looked at a person that is mentally retarded could not be subject to the death penalty. They would not understand what that punishment is necessarily for. Persons under the age of 18 can also not be subject to the death penalty. So infants, under Old English common law, determine a child under the age of 7 was an infant. At the same time, a person 7 or above was considered able to stand trial and were punished during this time period, just like they would of an adult. So think about a 7, 8, 9-year-old child. During that time period, we would have held them to the same standards that we would have held an adult. Today, an infant under civil law is a person who's not reached the age of maturity, so generally 18 and above. But at the age of 14, most states infer that individuals are competent and capable of committing a crime. So when we look at that, a person 14 and above, we're going to go ahead and take into consideration that they knew what they're doing, knew what they were doing was wrong, and if the crime is bad enough, we'll punish them through a certification and maybe punish them like an adult. So as far as proving infancy, so remember infancy as far as our terms just means child. Child under minimum age, typically 7 or 8, cannot be convicted of a crime. 7 and 14 presumed incapable of committing crimes, but presumption can be overcome by facts. So we show that that person understood what they were doing was wrong. Over maximum age, usually around 14, child is presumed to have adult capacity. So that's that age right there. And we can go both ways. We probably all met people that were very mature at a young age, and then we've met people that were very immature, did not make great decisions, even though they may have been considered an adult in all realms. So state statutes may either require children to be adjudicated in the juvenile court system, or the court can go through and put them into the adult system with a process called certification in our state. The younger the child, the more evidence is needed to show as far as capacity, did they understand? So a juvenile court, delinquency is conducted by a child that would be a crime if committed by an adult. So when we say that a person under the age of 17 committed a burglary, we don't say they committed a burglary. We say that they would have committed a burglary, the crime of burglary, if committed by an adult. So we add that extra line in there. So dispositions are usually not considered punishment. So where you would be found guilty, as far as a trial go, you'll get a disposition in a juvenile court. Created to focus on rehabilitation. We look at a child as a person that doesn't necessarily need punishment per se, but we're trying to bring them back in to be a productive adult. And think about when you were a child. You probably made some decisions just like I did that weren't the best, but it was a childish or young person's decision. And we're going to grow out of that as we age, become more responsible as an adult. So states pass laws that limit juvenile jurisdiction, and then we change as far as our time periods go. So juvenile courts became less in loco parentis as far as in place of the parents, and then more adjudicative or adversarial. So we go from the courts trying to take care of the kids, help with rehabilitation, to actually looking at treating them in a punishment phase. The 1980s is a good example of this. We started looking at juvenile crime and violence and, a little bit more punishment towards that juvenile offender with crimes and gangs. Teens now try as adults in certain felonies. If we look at this is our RSMO statute. And so here's a certification for how we would do that certification and where it would go as far as what we would do. So, and this has to be with a petition. Petition alleges that a child between the ages of 12 and 17 has committed offense which would be considered a felony if committed by an adult. The word felony is going to be, a major part of this. It doesn't say misdemeanors. It doesn't say infractions. And I would suggest to you that you go through and read our statute, especially those that are looking at going into juvenile law. Some of the criteria that we would look at when we're looking at juvenile: the seriousness of the offense, did the offense involve viciousness, force, or violence, was it against persons or property, is it a repetitive pattern, does this person keep doing that, and are they beyond rehabilitation under the juvenile code. So history of the child, including experience with the juvenile justice system, sophistication and maturity of the child. So how does this child act in the real world where they're dealing with other people? The age of the child. You notice that we go through these before we actually reach the age of the child. Program facilities available to the juvenile court. And just start reading down through these and go through them. Juvenile law is very, very interesting, especially if that's what you're looking at going into as far as your career. So insanity. The insanity defense is used as an excuse for conduct. It doesn't say that they didn't do it. It's just an excuse for why we should not punish them, and as a reason to prohibit criminal punishment, so especially execution. Very low success rate. So 2% of murder and felony cases are going to be successful. So if the defendant is found insane, a judgment of not guilty by reason of insanity is then entered by the court, and the defendant will be committed to a mental institution under that laws of the state. Faucher v. Louisiana, state must establish insanity and dangerousness by clear and convincing evidence in order to confine an insane convict beyond her criminal sentence. So, case right here, Robert Deere killed 3 persons in Colorado. I would encourage you to look this person up and listen to him talk. There's several YouTube videos out there, and just watch his behavior, how he interacts with his attorneys and with the court. So few states require a prosecutor to prove sanity. Usually it's going to be up to the defendant to prove that they did have that mental disease or defect at the time. As far as insanity tests go, we have McNaughton, product rule, and substantial capacity. So McNaughton rule, an insanity test that claims the defendants are not legally responsible for their acts if due to the defect of the mind at the time of the crime. So when we look at Missouri statute, a person is not responsible for conduct if at the time of such conduct, as a result of mental disease or defect, was incapable of knowing and appreciating the nature or wrongfulness of their conduct. So we start looking at these two, and we see a lot of similarities that go between there. 2 prongs of McNaughton: cognitive incapacity, moral incapacity. Could they think through this and know what they were doing was wrong? And showing the defendant did not know he was doing was wrong as far as that moral incapacity. Another interesting case that I would suggest that you look up, James Holmes was found sane and guilty of 12 murders after entering the Aurora, Colorado movie theater. If you've studied this case whatsoever, in one of the first photos that come out, this subject had very bright orange hair, and definitely had an interesting look to him that you could make some assumptions. And again, assumptions not going to be great, but again, I'd encourage you to look this person up and pay attention to how he interacts in court, the look he has at the first of this trial versus the look after he's sentenced. So, criminal proceedings involving mental illness. And when we start looking at the state statutes, we can go through all of these and say, hey, this is what this is, a definition of mental disease or defect. And I'm going to, this PDF will be on your website. So if you want to look through these and start reading a little bit more, and these are not long reads. They definitely are kind of succinct in their message. Product of mental illness: volitional incapacity or irresistible impulse, knows action is wrong but they can't control themselves. So an old saying that you might have heard before is the devil made me do it. I just couldn't control myself. Began as an addition to McNaughton rule because the right or wrong is too broad. the rules was modified in the Durham test, and accused is not criminally responsible if his unlawful acts was a product of mental disease. Rule not adopted in many states, so this is not the most popular one. Substantial capacity test. Can they distinguish between right and wrong, and then can they conform their conduct to the requirements of the law? So a psychopath is excluded from this just because we're looking at public safety. They're going to repeat this offense again and again. So mental conditions that do not satisfy the insanity offense include voluntary use of drugs or alcohol. You will want to reread that again. Other issues may be compulsive gambling, television intoxication, premenstrual syndrome, and then so-called cultural defenses. Jury instruction problem. Courts have struggled with instructions to the jury in cases where the insanity offense is raised. And then certain states say we're not going to have this at all. So this will change over time. Consequences of insanity verdict. In many states, and federal prosecution's commitment to mental institutions is mandatory. So if you are found insane, you're going to have to go somewhere where there's some type of treatment. Release date is subjective in that the medical field will look at whether they think that you can be released or not, and then that will go through the court system. A defendant who is found not guilty by reason of insanity is almost always committed to that mental institution. And again, the doctors will evaluate and work with the courts to determine if and when there will be a release date. Guilty but mentally ill. Defendant may be found guilty but mentally ill if the following. Defendant is guilty of the offense, so they did it. Defendant was mentally ill at the time they did it, and the defendant was not legally insane at the time the offense was committed. So a jury can find a defendant not guilty by reason of insanity or guilty but mentally ill. So the guilty but mentally ill verdict does not abolish the insanity offense. It simply recognizes there are graduations degree of mental impairment. So it makes that person accountable and pushes treatment. So we look at this as one of those to protect the public. People that are found insane that could be released definitely does not make the public feel safe versus that guilty but mentally ill, where they may push a little bit more as far as how long we're going to keep that person in there. So guilty but mentally ill, burden of proof. Defendant is guilty of the offense. Defendant was mentally ill at the time offense was committed, and the defendant was not legally insane at the time the offense was committed. So legally insane but guilty and mentally ill are two different terms. So not sufficient mental conditions for insanity, battered woman syndrome. That is actually a partial defense when we look at this in the state of Missouri. So battered spouse syndrome, there are a lot of steps that a person has to go through if they're going to use this as a defense in a case where they have been charged. I would again encourage you to read these as far as how they file this. They even go so far as to the qualifications of a person doing treatment has to have before they can bring this up. Voluntary use of drugs or alcohol. We've talked about that before and you've read that. So certain states will accept that. It's not a complete defense to criminal responsibility. Defense for criminal responsibility based on the fact that because of mental or emotional condition, defendant did not possess the required mens rea for conviction. So in most states, defendant's voluntary intoxication of drugs may serve as a basis for diminished capacity. We're not saying that they didn't do it. We're not saying that they don't have responsibility. It's just diminished capacity at the time. Now, if you read Missouri statutes, that's a no. But in some states, it will work as far as diminished capacity goes. This is the Twinkie defense. I would encourage you to read this. It's very interesting. And there was actually a movie made off of this. So maybe you've heard of the Twinkie defense, maybe that you haven't, but it's well worth reading, and it's not exactly what you think it is. So before you say you can get off by eating Twinkies, as far as a criminal conviction, read the case first and then go through and see what happened. So competency to stand trial. A person's mental condition is such that he or she lacks capacity to understand the nature and object of the proceedings. Needs to be able to communicate with their counsel. If they cannot help their counsel or work with the defense, there's going to be issues as far as getting that person through the trial. So a defendant may be found competent to stand trial, but incompetent to act as his or her lawyer. So let's say a person, they understood what was right and wrong, but at the same time, they've got some cognitive issues that would limit them as far as acting as their own attorney. The court can turn around and, based off this, can say, no, I realize you want to act as your own attorney, but we're going to have somebody help you that is a competent attorney. So civil commitment. So a person convicted of violent crimes, mainly sex crimes, may be committed for an indefinite period after their sentence is served. So this is for that person. We look at that like predatory, child sex offenders would be a great example. There's a high propensity this person may reoffend. So instead of letting them out and for the risk, we do a civil commitment. This is our civil commitment as far as state statutes go. So when we start reading this, procedure for likelihood of serious harm, when a mental health coordinator receives information alleging that a person as a result of mental disorders presents a likelihood of serious harm to themselves or others, they shall conduct an investigation, evaluate the allegation, reliability and credibility, and then they work their way through this to say, okay, we need to keep this person in some type of facility. Now, it's not going to be considered a prison, but from the outside looking in, it definitely that person's locked up and they're not free to leave. So criminal liability of corporations, and we've mentioned this before. Corporations are persons for purpose. As far as a person's corporation can be held criminally responsible for actions taken by officers or employees. So the people that work and or own that. When we look at our state statute, again, that coming from Chapter 2 again, a person is criminally liable for conduct constituting an offense which he or she performs or causes to be performed in the name of or in behalf of a corporation. So our state statute definitely says that we can hold, people and corporations responsible, definitely civilly, and then criminally we have to charge an actual person that committed the act. We can't criminally charge per se a corporation. We could civilly file a suit against them and get injunctions to stop certain actions. So children below a certain age, usually 7 or 8, cannot be convicted of a crime. Children between the minimum age of 12 to 14 are presumed to lack capacity, but we can overcome that. So it is rebuttable. Remember, we're going to dispute that, they committed the act, and we're going to say that they knew what they were doing. So certification, we talked about this before. Child under minimum age can be certified as an adult. It does have to be a felony, and you can go back and read the statute that I showed you earlier. So cognitive versus volitional. Cognitive rules examine what the defendant knew about his actions. What did they understand? Cognitive means thought, thinking. Volitional rules examine the ability of that person to control their conduct. Could they control their actions? So not guilty versus guilty. A verdict of not guilty by reason of insanity results in an acquittal. Basically, that person has no criminal conviction. A verdict of guilty but mentally ill is a conviction, but the defendant must be given treatment during their confinement. So competency factors, mental illness, mental retardation, mental forms of physical illness may be the basis of finding a person incompetent to stand trial. So unless the condition is cured, the defendants cannot be tried for the crime. Defendants may be confined while the competency is being determined. So they may be, locked up in some type of a medical facility, a closed facility, for lack of a better word, where they can't get out. But when it's determined that they are competent, they can be tried. So at which point the courts and the medical community agree this person knows what's going on, they can go ahead and have that trial. So a person who lacks competency does not have the ability to understand what is happening at trial and thus lacks the ability to participate in their own defense. So at the point we do think that they understand, then they are going to be considered competent. So as far as due process just means basically treating everybody the same. When we remember due process, I want you to remember the Fifth Amendment on the federal side, and that the 14th Amendment applies that to the states. Requires persons charged with crimes to be given an opportunity to consult with counsel and assist in their own defense. So lack of competency makes that impossible. So that's why we have to go through that process. It's going to be up to the defendant to prove that they are not competent. Responsibility, the defense of insanity, diminished capacity, and age are considered legitimate excuses for criminal behavior. But again, it's going to be up to that person as a defendant to prove those, and it's not going to entirely eliminate as far as their blameworthiness. The criminal law is designed to punish only those that truly are blameworthy as far as their conduct goes. Again, look at your reading. Definitely look at your vocabulary words. We're going to keep hitting these pretty hard. And the next chapter we're going to look at is use of force.